have discussed a right to freedom, that is freedom of speech and expression, freedom to association, freedom to assemble, and a right to freedom of right against arbitrary arrest, and right to personal liberty we have discussed. In this class, we will discuss a right against exploitation, that is come under Article 23 and 24, and a right to religion, that is come under Article 25 to 28. Let us start a right against exploitation. According to the Indian Constitution, slavery, beggarism, bonded labor, and other forms of forced labor are illegal. To engage the children under the age of 14 years in risky works such as in the factories and mines are unlawful. Many individuals in our nations are disadvantaged and impoverished or subjected to exploitation by the others. Article 23 and 24 of Indian Constitution ensure human dignity and protects individuals from exploitation. These are important fundamental guaranteed right, protects the individual from any kind of forced labor. This right is available to citizens of India as well as to non-citizens. The Indian Constitution protects the individual's dignity by ensuring the right against exploitation. In pre-independent India period, the social conditions is not conducive for the development of harmonious relations between people. The various evil practices like beggary, traffic in human beings, Devadasi system, bonded labor, untouchability, etc. are vibrantly practiced during that period. Hence, framers of Indian Constitution resolved to do away from all these inhuman and uncivilized practices. Articles 23 and 24 are the specific provision to deal with the problems which go contrary to the dignity of the individuals. Therefore, state forbids the above types of abuses or misuses of evil services or practices through the coercion or inducement by making law. Article 23 prohibits the traffic in human beings and forced labor. It provides that traffic in human beings and beggary and other similar forms of forced labor are prohibited. Any contravention of this provision is considered to be an offence and punished according to law. Exploitation implies the misuse of others' service by force and or labor without payment. In pre-independent period, there were many marginalized communities in India who were forced to engage in manual and agricultural labor without any payment. Labor without payment is known as beggar. One cannot be forced to engage in labor against his or her will even if remuneration is given, because Article 23 forbids any form of exploitation. Forced labor is forbidden by the Constitution. If less than minimum wage is paid, is considered to be forced labor. These articles also make bonded labor unconstitutional. When a person is forced to offer services out of a loan or debt that cannot be repaid, the Constitution makes coercion of any kind is unconstitutional. Thus, forcing landless persons into labor and forcing helpless women into prostitution is unconstitutional. The article also makes human trafficking is unconstitutional. It involves the buying and selling of men and women for illegal and immoral activities. The human trafficking is illegal trade in human beings for the purposes of commercial sexual exploitation, prostitution or forced labor. It is considered as modern form of slavery. Even though Constitution does not explicitly ban slavery, Article 23 has a wide scope to include the word slavery in the terms forced labor and traffic. Article 23 protects citizens not only against the state but also from private citizens. The state is obliged to protect the citizens from these evils by taking punitive actions against the perpetrators of these acts and also take positive actions to abolish these evils from society. Under Article 35, the Parliament is authorized to enact laws to punish acts prohibited by Article 23. Laws passed by the Parliament in pursuance of the Article 23 are Suppression of Immoral Traffic in Women and Girls Act 1956, Bonded Labour System Abolition Act 1976, Abolition of Begging and Rehabilitation of Beggars Act 2018, etc. Let us come to Article 24. Article 24 lays down that no children below the age of 14 years shall be appointed to work in any factory or mine or engaged in any other hazardous employment. This article helps in improving the physical and mental activities of children. It is distressing to note that in spite of the constitutional prohibition against employment of children, still it is continuous in many parts of country even today. This article absolutely prohibits employment of any children in any factory, any hazardous industry or mines. It does not allow even any exception, although it implicitly allows the children to work in a non-hazardous nature of work. In pursuance of the Article 23 of Indian Constitution, the Child Labour Prohibition and Regulation Act 1986 was made, which prohibits the employment of children below the age of 14 years in certain occupations such as automobile, workshop, beadie making, carpet weaving, handloom and power loom industry, mines and domestic works. This act regulates the conditions of work of children in any other occupations. Child Labour Prohibition and Regulation Amendment Bill 2012 was introduced in the Parliament in the light of the right of children to Free and Compulsory Education Act 2009. The Child Labour Prohibition and Regulation Amendment Act 2012 prohibits the employment of children below the age of 14 years in all occupations except where the child helps his family or family enterprises in non-hazardous occupations or enterprises, that too after his school hours or during vacation. Similarly, a child working as an artist in an audio-visual entertainment industry, advertisement, films, television serials or any other entertainment or sports activities except the circus. In both cases, The law requires that permission is subject to such conditions and safety measures as may be prescribed and provided that such work does not affect the school education of the child. By making this RTE Act, the right against exploitation has become more meaningful. It will be an offence to employ the children not only in factories or industries but also in homes and roadside kiosks and all forums if their labour is meant to serve any commercial interest. In the light of Right of Children to Free and Compulsory Education Act 2009, Child Labour Prohibition and Regulation Amendment Act 2016 prohibits the employment of children below the age of 14 years in all occupations and processes. Earlier, this prohibition was applicable only to 18 occupations and 65 processes mentioned in the schedule. Further, the amendments also prohibits the employment of adolescents in the age group of 14 to 18 years in hazardous occupations and processes, regulates their working conditions where they are not prohibited. The amendment also making the offence of employing any child or adolescent in contravention of the Act by an employer as cognizable and provides stricter punishment for the employers who violates the Act. Let us come to the next topic, that is right to religion. Come under Article 25 to 28. The Constitution provides for freedom of conscience and right of all individuals to freely profess, practice and propagate religion. Mandates a secular state, requires the state to treat all religion impartially and prohibits discrimination based on religion. The right to freedom of religion is well described in the Articles 25, 26, 27 and 28 of Indian Constitution. The freedom of religion conferred is not confined to the citizens of India alone but extend to all persons including aliens. Individuals can exercise their right either in their individual capacity or on behalf of some church or institutions. It enables the state to adopt secularism. India, being a secular nation, gives every citizen the right to follow the religion he believes. The word secularism means separate from religion. It enables is an entirely personal matter. India, being a secular country with no state religion, and there should be equal respect for all religions and faiths. All religious groups in India have the same powers without any discrimination. To understand it more clearly, secularism is defined in S.R. Bommai versus Union of India, wherein it was held that secularism is the basic feature of Indian Constitution. Religion is a matter of individual faith and cannot be mixed with secular activities. Students, what do you mean freedom of religion? That means every person is entitled with this right and liberty to practice, preach and propagation the religion of his choice, and no one is prohibited of right to practice, profess, of his religion. An opportunity is also provided by this right to spread it among everyone without any fear of governmental intervention. India is a land of diversity in terms of race, religion, creed, caste and community. When it comes to exercising one's religious faith, state should be neutral, unbiased and impartial. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion subject to public order, morality and health. This right allows every person to possess and enjoy the right to profess, practice and propagate a religion of his or her liking. The same article empowers the state to impose restrictions on the religious freedom of persons on the ground of public order, morality and health. In Vijay Emmanuel versus State of Kerala, this is also popularly known as National Anthem case. The children belonging to Johovo community expelled from the school for not singing national anthem on the ground that in Vijay Emmanuel versus State of Kerala, this is popularly known as National Anthem case. The children belonging to Johovo community expelled from the school for not singing national anthem on the ground that they committed an offence under National Honours Act 1971. The circular issued by the Director of Kerala has made it obligatory for students in school to sing national anthem. The children in this case stood up respectfully when the national anthem being sung at their school, but they did not join in singing it. The Kerala High Court upheld the expulsion of the student, but the Supreme Court reversed the decision of Kerala High Court and held that they did not commit any offence because by standing up they shows they have full respect towards national anthem. As far as they were not singing national anthem is fully covered under Article 25 of Indian Constitution. In Sesamal versus State of Tamil Nadu case, the hereditary Archakas and Matadipatis of some ancient Hindu public temples in Tamil Nadu challenged the validity of Tamil Nadu Religious and Charitable Endowment Act 1979 on the ground that it violates their rights guaranteed under Article 25 of the Constitution. The issue was Archakas were appointed based on heredity, but by virtue of the act, anybody who is well versed, irrespective of caste, can become Archakas if he performs the puja of the deity as per Hindu mythology by reciting proper mantras and by performing rituals. Court held that any person who can recite mantra as per Vedic order and who is well versed as per practice of Hindu religion can become Archakas, and hence no such fundamental right is available to these Matadipatis to appoint Archakas as per heredity. The freedom to manage religious affairs is provided by Article 26. Article 26 does not deal with the right of individual but is confined to a religious denomination. Article 26 refers to a denomination of any religion, whether it is a majority or minority religion. Just like Article 25, it refers to all persons. Students, I want to give some examples in order to understand what are religious denominations. Sunni and Shia are religious denomination in Muslims. Catholicism and Protestantism in Christianity. Many practicing Hindus do not claim to belong to any particular denomination or tradition. Four major traditions are, however, used in scholarly studies are Vaishnavism, Shivaism, Shaktism and Smartism. Article 26 guarantees every religious denomination or section thereof with right to establish and maintain the institution for religious and charitable purposes, manage its own affairs in matters of religion, own any movable or immovable property and administer such property in accordance with law. The word religious denomination is not defined in the Constitution. The word came to be considered by the Supreme Court in the case of Commissioner Hindu Religious Endowment Madras versus State Sri Lakshmendra Tirtha Swamiyar of Sri Shirur Mutt. In this case, court held that the word denomination means a collection of individuals classed together under the same name, a religious sect or a body having a common faith and organization designated by a distinctive name. However, this right has to be exercised in a manner that is conformity with public order, morality and health. The right to manage religious affairs implies the right to determine what rituals and observances are essential according to its religion, and in what manner and for what purposes its income is to be spent and its property has to be utilized. The right to administer property implies the right to acquire and dispose property, the right to manage its own affairs in the matters of religion. The matters of religion includes religious practices, rituals, observances, ceremonies and mode and manner of worship, etc., regarded as essential and integral part of religion. In Achara Singh versus State of Bihar, court held that whether in mud or temple, a certain quality of food be offered as bhog to the deity or adithis as a part of well-established ritual of the institution. This practice should be held to be a part of religion guaranteed under Article 26 Class B, has the right to administer its own property, but it should be in accordance with law. The Supreme Court in State of Rajasthan versus Sajjanlal Panchawat observed that even though state has the power to administer or regulate the properties of a trust, but it cannot by law take away the right to administer the property which vests in the authority of any religious denomination, because this would certainly amount to violation of right guaranteed under Article 26D of the Constitution. Right to religion under Article 26 is subject to certain limitations and not absolute and unfettered. If any religious practices is in contravention to any public order, morality or health, then such religious practices cannot claim protection of the state. Article 27, freedom from taxes for promotion of any particular religion. Article 27 of the Constitution prevents a person from being compelled to pay any taxes, the proceeds of which are incurred for the promotion or maintenance of any religion or religious denomination. This article provides an exemption to pay tax for religious activities, and this provision prohibits only the levy of a tax and not the fee. Other meaning of this article: the state shall not spend the public money collected by way of a tax for the promotion or maintenance of any particular religion. This means tax can be used for the promotion or maintenance of all religions in an equal manner. Student, I hope you understood the concept of a right to religion as well as a right against exploitation. In the next class, we will discuss the minority educational right.